2026 at the Indian Law Institute, New Delhi. At the outset, I must congratulate the Law Institute, the Commonwealth Legal Education Association, and the Institute of Legal Advocacy and Training for conceptualizing a program that places mentorship at the heart of legal research. The structure of this initiative itself reflects seriousness of purpose. It's not designed as a routine academic event, but as a carefully curated 6-week intellectual journey involving participatory self-study, residential training, personalized mentoring, and publication-oriented research development. I was particularly struck by the breadth of themes incorporated into the program design, from doctrinal and empirical methodologies to interdisciplinary approaches, digital research competencies, academic writing, and publication strategy. Equally significant is the emphasis on sustained mentor-mentee engagement beyond the classroom. In today's world where information is available in abundance, but thoughtful scholarship is increasingly rare, such initiative assumes tremendous importance. The law has always evolved through ideas. Behind every constitutional doctrine, every transformative judgment, every legislative reform, there was first a question raised by someone willing to think deeply. Research, therefore, is not an accessory to law, it is central to the development of law. Very often, when we think of legal education, we focus on professional outcomes, litigation, corporate practice, judicial service, or academia. But beneath all these paths lie a common foundation: the ability to think clearly, analyze deeply, and reason carefully. And these qualities are cultivated through rigorous research. One concern I increasingly have is that we may be gradually losing the habit of deep reading. We live in an age of summaries. Judgments are reduced to short notes, arguments to headlines. We want conclusions instantly, often without engaging with the reasoning that produced them. But law does not reveal itself to that impatient reader. A constitutional judgment cannot be understood merely through the operative portion. A precedent cannot be appreciated without understanding its context, its evolution, and sometimes even its silences. The finest lawyers and judges that I have known were invariably serious readers. They read not merely law reports, but history, philosophy, literature, economics, and political theory, as well as sociology. They understood that law does not operate in isolation from society. Indeed, some of the most important constitutional insights emerge where law begins to converse with these disciplines. That is why programs such as this are valuable. They encourage participants not merely to gather material, but to cultivate what Professor Shivakumar has mentioned, intellectual discipline. And discipline is essential to scholarship. Research is not merely about finding authorities that support our conclusion. Genuine scholarship often requires us to confront uncomfortable facts, reconsider assumptions, and occasionally accept that our initial position may have been mistaken. That intellectual honesty is the soul of academic integrity. The program brochure very thoughtfully recognizes another contemporary reality, that legal scholarship today must engage with technology, interdisciplinary methods, and global research practices. The inclusion of training in digital legal databases, research visibility tools, citation management systems, anti-plagiarism protocols, and interdisciplinary approaches demonstrates a modern understanding of legal education. Today, legal research is also being transformed by technology, artificial intelligence, and today no talk on any subject can go without mention of artificial intelligence. You are considered almost an illiterate if you don't mention it once. I am not mentioning it for that reason. Artificial intelligence can now summarize judgments, identify precedents, generate drafts, and process enormous volumes of information within seconds. Naturally, this creates both excitement and anxiety among young lawyers and researchers. But I believe technology should be viewed as an aid, not a substitute, a topic Hon'ble Chief Justice has been talking about. While artificial intelligence can be partnered, you cannot jettison your core function. substitute that with artificial intelligence. Machines can organize information, they cannot replace human judgment. A machine may identify patterns in precedent, but it cannot appreciate the lived realities behind constitutional disputes. It cannot understand the anxieties of a vulnerable litigant, the silence of a marginalized community, or the moral tensions underlying difficult questions of justice. The future, therefore, will belong not to those who merely possess information, but to those who can think independently about information. And that brings me to mentorship. I'm really touched to hear the story of Sir C.V. Raman and his disciples. There's something which I've not heard of before, that he forsake an invitation from the first citizen, not only to stay with the Rashtrapati Bhavan, but also to receive the award on the ground that the mentee was on the verge of completing their research project, and to leave him, abandon him now, would be detrimental to his dharma. One of the strongest features of this program is its mentorship-driven structure. The brochure repeatedly emphasizes continuity of engagement, structured evaluation, iterative feedback, peer learning, manuscript review, and guided publication support. This is precisely how serious scholarship is nurtured. It's also heartening